We're on the record in cause number 326338. The case is styled the state of Texas versus Curtis Daniel Johnson. We have Mr. Johnson in court. Okay, now, for the record, your name is Curtis Daniel Johnson, is that correct? Mr. Johnson, would you raise your right hand? Your other hand. Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Johnson, you may put your hand down. How you doing, Mr. Johnson? You doing all right? All right, Mr. Johnson, we're taking a record, so you're gonna have to speak up. Now, Mr. Johnson, you were here in person, and your attorney, Mr. William Wilkerson, is appearing via Zoom. Mr. Wilkerson, how are you doing?
I'm doing fine, Judge.
That's good. Now, Mr. Wilkerson, the court, this case is set for an informal inquiry pursuant to 46B.004 of the Texas Code of Criminal Procedures. Mr. Wilkerson, Article 1.24 states that the proceedings and trials in all courts shall be public. And that's Article 1.24 of the Texas Code of Criminal Procedure. In the case versus Liddy versus State, 365 Southwest 3rd, 321, the court stated that the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Now, pursuant to that article and pursuant to this case, are you desiring to close this case to the public because there may be a disclosure of non-public information?
Yes, Your Honor, we would waive the open hearing requirement as I understood the rules to be promulgated by the Supreme Court in the matter of Zoom hearings.
Okay, so the court is going to find that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudice to his client. The court will all further find that the closure is no broader than necessary to prevent that interest, to protect that interest. And the court have considered reasonable alternatives to closing the proceeding. And the court has made an adequate findings to support the closure. And therefore, at this time, pursuant to Lilly versus State, 365 Southwest 3rd of 321,